This presentation covers equitable distribution for the family law course, and I've woven together in this the Lupino Fitzgerald Miller book as well as the Keene book. And on the last slide of the presentation you'll also find that I've got a list of other resources that should help you. Before we get started on equitable distribution, let's do a quick review of debts, liabilities, and assets. Some of you have not taken courses on these topics or may not have a lot of personal experience in these areas. As such, it's a good idea to lay a foundation so we can make some sense of the areas that apply to equitable distribution. First, there are different classifications of debts. Debts can be classified in one of two different ways. A debt is either considered to be secured or unsecured. So in order to understand the impact that these type of debts can have on basically what are the final assets to be distributed, we need to look to help us understand what constitutes both secured and unsecured debt. Obviously, as shown here, a secured debt is any debt that requires collateral in order to obtain a loan. Some examples are your home mortgage, a home equity line of credit, a car loan, and there are credit cards as well that with a secure line of credit. For example, when you purchase goods from a major electronics store or business or office equipment store, you probably are signing a credit card that is not unsecured, like the credit cards we're going to discuss next. An unsecured debt is basically the opposite of a secured debt. Anything that you receive a loan or line of credit with no collateral, like a car or a mortgage attached to it, it's an unsecured debt. Examples are credit cards, department store cards, signature loans, telephone bills, health club fees, magazine club fees. Also, in looking into family law in terms of equitable distribution of the marital assets and liabilities, we have to look to understand debt load, and that there's joint debt and individual debt. Basically, the sum of all money owed by a couple or each of them individually is calculated using the amount due, the principal amount due on the mortgage, the student loans, the credit cards, loans from family and friends are also included. Joint debt are those debts that are concurrently concurrent liability between both the husband and the wife. Whereas if one person individually has debt, it's owned solely by either the husband or the wife. A couple of things about debt when we're dealing with family law is, even though a debt may be a concurrent liability between the husband and the wife, and let's say the judge orders that it be split in two, the original contract with the lender, the bank or mortgage company or whatever, is always going to be what the original, what that bank or mortgage company looks to when collecting the debt. So the judge can say half and half, but when one doesn't comply with that, too bad. It's kind of one of those sad things about dissolution of marriage when they divide those debts. If one doesn't pay or one goes into bankruptcy, although there have been some changes to the laws in the bankruptcy realm, but as a general rule, it's still a joint debt. And the courts will not just ask, or I'm sorry, the creditor that you owe the money to will not say, oh sure, send me a copy of the divorce decree and we'll only expect half from you. Just one of the unfortunate things that happens in dissolution of marriage. Next, let's look at assets, also known as property. Something a person owns or controls. You know, it's a simple word in terms of if you own and control or benefit from its use in some way, it's an asset. And it may be something which directly generates revenue for the family, like a second home that is rented out to others, or a retirement fund, or it may be something which supports the family operations of the, such as the marital home and cars, that sort of thing. And here's a list of the items that when you're looking at the information a client brings to you that you would place into the category of assets. It's also important to understand that there is a difference between real property and personal property. Real property, we also call it real estate. This is the land and the items growing on it permanently or permanently attached to that land. And personal property is the property that's not real. It's the tangible things that can be touched or moved. But yet they're sometimes intangible. Intellectual property is an example. Stocks that aren't evidenced by a certificate in today's electronic age would also be an intangible personal property asset. There are different ways in which people hold the title to property. Real property may be owned by a single owner or by a group of owners. When a single owner owns real property, this is known as ownership in severalty. Tenants by the entireties is a form of legal title that only applies to married couples. Divorce will extinguish this type of ownership, obviously, and this type of ownership is not available in all states, but it is available in Florida. As Keene notes on page 90 of his book, the law creates the presumption that all real property held by the parties as tenants by the entireties is presumed to be a marital asset. Property held by spouses and tenants by entireties belongs to neither spouse individually, but each spouse is seized of the whole. So the whole property is owned by each of them, even though they each have an interest together. Tenants in common is a form of legal title that can happen between two or more persons. There is no right of survivorship. In other words, if one tenant dies, the other one would take ownership of that tenant's share. If a deed doesn't say how the ownership of the property is held, the ownership will be deemed a tenancy in common. So why are these forms of ownership important to the family law paralegal? Well, a couple of reasons. First, you have to be able to describe the value of the property ownership, when you're looking at the client information, and eventually the property will be divided, and understanding these principles will help you do this task. Second, you may be called upon to help with the evaluation of some deeds to real property and to make judgments on how property is owned when the client isn't really sure of this. And third, the date of the ownership will help the paralegal make judgments on whether property is considered marital or non-marital, particularly in cases of ownership in severalty, tenants in common, and joint tenancy. Title to property. So when we have real property, we have a deed, and we look at those to figure out what is our title to the property. The most personal property does not include a title. Some exceptions are the vehicles, bank accounts, brokerage accounts, and stocks. They do have, a paper or an electronic sense where for stocks and brokerage accounts are concerned. There is something that says this is jointly titled, a written type of document, if you will. The same presumption of joint ownership applies to personal property held by the entireties, whether the property was acquired prior to or during the marriage. Over time, the courts have adopted the common law rule that both real and personal property could be held as tenants by the entireties. And even though the courts have recognized that the tenants by the entireties form of ownership could exist in real and personal property, the laws relating to all the requirements to form tenants by the entireties have really evolved separately. And it is really inconsistent, to be honest with you, between the two. So it's just something that you have to look into and do some research each time when you're faced with a situation where you're making this determination. One of the things that's important here is the rights of third-party creditors, and Keene talks about third-party creditors as well in his book. They're particularly invested in this conversation we're having about tenants by the entireties and personal property, because of course, they want to get their money for debts, or they want to, that are attached to the property. So suffice it to say that, we need to know this presumption in predicting how personal property may be divided equitably in a dissolution of marriage. And there are some situations where the need to distinguish the ownership type in a divorce case is important, such as when the division of property is not desired. A division as in don't judge, consider this a tenants by the entireties and try to divide it as close as you can to halfway, because that's what we're going to learn is the presumption. But sometimes there's a dispute of that in court and in the divorce proceedings, and people might try to remove that barrier by saying, oh, well, I didn't have that intent of creating a tenants by entirety ownership when I put my spouse on the bank account after the marriage took place, because, well, I wanted to just make sure that if I die on inheritance, there would be an inheritance, but it wasn't for for example, an intent to make this a tenants by the entireties title. So that's kind of thing there that we run into that. The presumption of bank accounts being tenants by the entireties title does not come, by the way, by the divorce statutes. This is an example of how we have to look to other statutes and other laws to make decisions as to whether something is considered presumed, in this case, a tenants by the entireties ownership. If you go to the title in the Florida statutes on banks and banking and just run a full text search of tenants by entireties, you will find that that's where we find out about the joint accounts and whether they're presumed tenants by the entireties or not, when they are presumed so. Motor vehicles, same thing, and we have when you go to the tax collector's office and title a new car, they'll ask you, do you want this in the and, as in spouse 1 and spouse 2 names, or as or. So that'll be the difference in determining whether that's tenants by the entireties. And the motor vehicles title of the Florida statutes tells me the answer to that question. Finally, the presumption of tenants by entireties title does not apply to property brought into the marriage. The property a person brings into the marriage is presumed to be his or her separate non-marital property unless there's a title transfer or a legal principle. For example, commingling money into the account after making that, even though it is still, not considered, even though the account is not a joint account, but both parties are putting money into the solely owned account. That's what we call commingling, and we'll discuss a little bit more of that later. So next. All right, so the Florida courts follow an equitable distribution scheme when they divide both property and debts of the marriage. All right, so equitable distribution is a legal concept in Florida, and it's used for dividing property accumulated during the marriage, regardless of how title is held by the spouses. That goes back to the earlier slides that I showed you on title. All right, equitable distribution. Interestingly, this case comes up again, Canacaris. Until Canacaris versus Canacaris, which was a 1980 Florida Supreme Court case, the concept of equitable distribution did not apply in Florida because the court's equitable powers didn't legally allow division of property owned in one party's name. We've talked about that before. Canacaris changed the divorce landscape forever by recognizing the concept of equitable distribution. Eventually, finally, the legislature adopted the same reasoning as Canacaris, and that is how equitable distribution finally became legislated and not something governed by a case law. Under equitable distribution, the court must divide the property equitably, but not necessarily equally. Okay, there's a presumption that there should be a 50-50 split of the property and debt unless there is a justification for an unequal distribution. That's where Canacaris came about. After the values of the assets have been determined, the court usually makes an equal distribution but can make an unequal distribution when the circumstances warrant. And the statute, the Florida statute that I've cited here, 61.0755A, the Florida statute provides several examples that might support an unequal distribution. The contribution of each party to the marriage may be a reason, or one party advancing the career of the other. But ultimately, the determination of when an unequal distribution is an equitable distribution is committed to the trial court's discretion. And remember what I mentioned in the alimony thing. Discretion is a very broad, sweeping power that the judges will look to all the facts and decide if the court's in the court's discretion if there should be an unequal distribution. So, the courts eventually, through case law, establish what we call positive rules of law in terms of written rules of law. And those will confine very much the discretion of the trial courts. That precedent that's established through case law will confine that a little bit more. All right, the process of equitable distribution is, usually consists of identifying marital assets and debts, determining their value, allocating them in kind to each party, meaning dividing them, allocating in kind to Mr., allocating in kind to Mrs., and to the extent feasible. And if the resultant distribution isn't equal, the court will order a transfer payment to rectify the difference. In cases where one party's contribution to the marriage merits extraordinary recognition, the court may order, as I noted earlier, an unequal distribution. Now, there are some material dates for property that we need to talk about. The dates for deciding if property is marital or non-marital is the date of the marriage. So we'll cover more on the definitions of marital versus non-marital property in the next slide. For now, the marriage date will suffice in explaining that when two people marry, everything after acquired is generally considered marital property, with some exceptions, obviously. The dates for identifying what property, be it marital or non-marital, should be determined or should be divided is determined by the date of the divorce. So basically, when one acquires property after filing for a divorce, it is presumed to be non-marital property. Also, the parties may have chosen a date in a settlement agreement, and this date could differ from these dates that the court normally looks to, and these are all governed by statute, mind you. A date of the filing, or if they have an agreement, the date of the agreement, would also be a date the court looks to in valuing the marital property. So as Keene notes in his book on page 94, it's possible some complications can develop. Take a look at those examples he gives on page 94. All right, so marital versus non-marital property. Property owned by either spouse before marriage is generally not considered marital property. And the same is true of gifts or inheritances received during marriage. This is Florida law. Income derived from premarital property, as well as any new property acquired in exchange for premarital property, are not marital. So the qualities of premarital property, if that premarital property is sold and new property is, and they've exchanged it, let's say, for other property, it's still not it can maintain that quality of non-marital property. That's what I'm getting at. Non-marital property, however, may become marital property under some circumstances, such as placing record ownership in both names, or in the case of financial assets, commingling with marital assets. I mentioned that earlier. When marital funds or labor are used to improve non-marital property, that resulting increase in value would be marital. All right, so understand that non-marital property can morph into marital property, and some of the ways that it morphs is by, well, first we're maybe changing record ownership in both names, commingling with marital assets, or putting in labor and increasing the value. So that piece of increase could be considered marital property if the facts are appropriate to consider it such. Pension or retirement funds, whether vested or not, are marital property to the extent they accrue during marriage. Lump sum alimony. Remember, we had this conversation already in a previous lecture. Let's first remember that alimony is never decided by the court until the property is divided. As Keene notes in his book, the property is often a source of income. It might increase the income of one party or decrease the needs of the other. This is important because, remember, the need and ability to pay are the factors the courts must consider when deciding on alimony awards. Now, before the Canacaris case, lump sum alimony was only permitted when it was tied to support. And that meant that the same criterion of need and ability to pay that applied to periodic alimony was also being applied to lump sum alimony because it had to do with support. However, the Canacaris case recognized that a spouse's non-financial contribution to a marriage could give rise to an equitable claim upon the property that was acquired during the marriage. At the time, the only legal basis for ordering a transfer of property was at the time a lump sum alimony. And so in Canacaris, the court adapted that mechanism to effectuate an equitable property distribution. So under Canacaris and its subsequent cases like it, lump sum alimony could now be ordered upon the showing of a justification, along with the ability to pay. This differs from the spousal support test of need and ability to pay. So that standard is need and ability to pay applies to all other forms of alimony, but lump sum alimony can be ordered with justification and ability to pay, and it is based on what the court found in Canacaris. And also has to be noted, and Keene notes this in his book, that there is a dilemma of lump sum alimony versus unequal distribution, because whenever there's a single, indivisible, and non-liquidable asset, like a family business he gives an example of, the only, when that happens, that's when the dilemma comes up. And that's where lump sum alimony versus unequal distribution would be applicable. The only other solution is to order besides lump sum alimony, is to order the party keeping the asset to buy out the other's interests in the asset with some specified payments. But if you look at that solution, it would obviously impact the alimony issue, because then the need for alimony as well as the ability to pay alimony could be affected. So at the end of the day, this vision of lump sum alimony is for property and not for spousal support. And at the end of the day, recognize that need and ability to pay are for support, and that lump sum helps to equalize things when it's necessary under the circumstances. Special equities. The term special equities is not included in this version of the textbook. However, I'm pretty sure it was included in the past editions of the book. It comes up because sometimes, because it'll happen, you'll probably be faced with this terminology in law practice because it's often misunderstood. Sometimes a special equity, to use the term just as it is described as sort of an invisible asset. It's not present in tangible form. And so the term special equities, has often been misused by the courts, and it's often confused with alimony. So let's talk about the case of Canacaris again. In Canacaris, the court clarified the term special equity, and the court directed that it be used only when analyzing a vested property interest. All right, a vested property interest there's an immediate fixed right of present or future enjoyment. So it's an immediate right and it's a fixed right. It may not be a tangible, so it's a future enjoyment or a present enjoyment. That's what a vested property is. The term vest is significant in the law because it means that a person has an absolute right to some present or future interest in something of value. When a right has vested, the person is legally entitled to what has been promised and may seek relief in court if the benefit is not given. The Canacaris court directed that special equity only be used when analyzing vested property interest. All right, so much going on with Canacaris here. Prior to Canacaris, there were two situations in which the court could order a transfer from the legal title holder in divorce proceedings. One was when the authority to find that one spouse held a special equity, all right, which was basically abolished. It was reformed in Canacaris. So this special equity in a specific piece of property legally owned by the other. So the other person, I think in Canacaris it was a business. One legally owned the business, but the other one had a special equity because of a vested right that I believe the missus contributed to. I'd have to read the case again. But a special equity could arise when one party had made extraordinary contributions to the acquisition or ownership of a specific piece of property. So, for example, if the wife's mother made a down payment on the marital home, a special equity could be recognized in the wife even if the property had been titled solely in the husband's name at the time it was purchased. So special equity plays a role similar to that of the doctrines of beneficial interest, of equitable title, or constructive trust, like our case of Marvin versus Marvin. And these prevail in other areas of the law, and we recognize an ownership interest in property titled in the name of another when the conscience of the court required it. The unequal distribution authorized, we had in 1988 statute, that's the one that says that it can be an unequal distribution. It replaced that special equity function by saying we can have an unequal, but it didn't abolish it, but it said we can have an unequal distribution. But this special equity thing kept persisting, and Canacaris changed that, and then the legislature finally abolished it. So special equities is looked at now as a way, it is not even seen as you shouldn't even use the term, but if you hear it, just realize that we're looking for a way to compensate one of the parties for a vested interest, usually an invisible asset in terms of that holder, the person who needs who's seeking that special interest. Invisible asset doesn't have any legal ownership to it. And a couple of examples that come up with special equities in the law practice is usually goodwill. Like a person owned a business, so they have more than this building and the lamps on the desks and the whatever equipment they have in that building for the business, but they also have goodwill that they've established over time with clients. A veterinarian, for example, has established goodwill with clients, and that's an invisible asset. We can't put our hands on it. And educational degrees, we've already talked about that. There is no such thing as a special equity or an ownership interest period in an educational degree in Florida. But these two cases, Thompson versus Thompson and Hughes versus Hughes, would be good ones to read if you want to look further into those two specific areas of an invisible asset. But special equities was formally abolished in 2008 when equitable distribution statute was enacted, permitting the equitable distribution and giving the judges discretion to look at some of these other factors to give an inequitable, I won't say inequitable, but a less than half and half split. Okay. One other area with regard to equitable distribution is what is called partition. Honestly, until I moved to Florida and worked for a family law practitioner, I had never heard of partition. So I think it's a good idea to tell you about it. Usually there are sufficient assets in the dissolution of marriage that the court has a way to split these apart. But some major assets can't be divided in what we call in kind, as in, here's a bunch of stock accounts or stock, they're divided up, you get half, you get half. That can be divided up by calling the transfer people and having them do that with the order of the court, the judgment of the court expressing how they should be divided. However, something like a home cannot be given in kind. Can't give one half to one and one half to the other spouse. And this is where partition comes in. And partition liquidates an asset so that it produces money that can later be divided. Anytime two people own property and one of them wants out, partition comes into play. In reality, there are many cases where one party doesn't have the money to buy the other out, and adding a count to the petition for dissolution of marriage allows the court to partition the property as a plausible alternative. A court can't partition property owned as tenants by the entireties. Obviously, parties each own a whole part of the property. However, as I noted earlier, when the parties become tenants in common when the divorce is granted. So a separate complaint would have to be filed after the divorce, to avoid having to do that separate work. But there's sort of, as Keene puts it, a wink wink rationale, I guess if you will, applied in divorce cases. And a petition for dissolution of marriage can include a count for partition. The court must find the parties jointly own the property, that their interests will be as tenants in common upon the granting of the divorce, and that the property is not susceptible to a physical division. The judge then orders the house be sold at public auction, and the proceeds, after paying all expenses, then are divided according to what the court's finding was as to their respective interests of the parties. So, but there are dangers that lurk in this. It's that the public sale will bring a low sale price. Some stranger buys it for pennies on the dollar. And, as such, most of the parties try to work cooperatively toward a private sale. But another danger is that one of the parties that wants the property, that has more money, can go to court and go to the courthouse sale or auction and buy it at a really low price, and then the person that is supposed to get half or a third or whatever of those proceeds gets less. It isn't right and it isn't fair, but it does happen. All right, so as far as the assets of a business, or I'm sorry, of a marriage, sometimes we have to get help from experts, and this was something that I would do often when I worked in family law practice. And first of all, sometimes part of the job of a paralegal is to maintain some information on valuation experts. These are people who are accountants and actuaries, financial planners, pension valuators, those type of bean counters, I want to call them. No offense to you if you are one. That can value assets. So we keep a resume, or what's called the Latin term that's used a lot is curriculum vitae, and it's a long resume. Or a CV, that's also called a CV, for the initials, curriculum vitae. A fee schedule you might have around in a folder or an electronic file, and always keeping them organized by areas of expertise. For property division concerns, the statute does provide for domestic violence and remember from the last class, the last lecture, the harm to the other party, on alimony, where we're looking at the way it's looked at is, can be looked at because of domestic violence, or the harm, to assist in aiding the harm a person has gone through as a result of the divorce. The point of the domestic violence experts, social workers, psychiatrists, and psychologists on this list is to help recognize that if those are factors that go into the courts making decisions, then we might need expert testimony from people who have treated the person or have gone in for a mental exam or something. Sorry, that was an email with a picture of my dog on it. That's what the little bell was for, if you heard that. Anyway, so that's what that's what the point is to recognize that some experts are going to be needed in several different areas sometimes. The effect of pre- or post-marital agreements on settlement agreements. A little bit of this again, just to throw it in once more. Remember that if equitable distribution is desired and a 50-50 split is presumed, unless there are these reasons for an unequal division, it may have also come around not by the factors given in the statute, but there may be an inequitable distribution because maybe someone's waived rights, maybe there's maybe a premarital agreement has a list that identifies what property is separate property, and then those marital agreements might also point out when a valuation date would be agreed to by the parties. Next, we have jurisdictional issues. The jurisdiction is a very complex area of law. I want to begin with that. But for the purposes of family law and talking about the property, we need to look at a couple of things, and these are noted in Keene's book. But for now, we'll confine the conversation about jurisdiction to those relating to property issues. First, there is subject matter jurisdiction. This type of jurisdiction determines whether the specific court, or for that matter the state, has jurisdiction over the subject matter of the case. In dissolution of marriage, the subject matter is the marriage. But also comes into play the property and like in the other case, alimony and that sort of thing. In Florida, the courts have jurisdiction when one of the parties has been a permanent resident of the state for 6 months before filing the case. That is a statutory provision. Second, there is venue. The proper venue of a divorce case is in the county in which the parties last resided as husband and wife. If a case is filed in an improper county, and this is often done for a variety of reasons. Maybe people don't want it to be so obvious or noticeable. The responding party, that's the respondent, has the right to insist that it be removed to the proper county. But if no one objects to the venue, i.e. if the responding party doesn't object, the wrong county can hear the case. Third, there is jurisdiction over the parties. The filing party has already submitted himself or herself to the court's jurisdiction by putting the petition for dissolution into the court's records. Jurisdiction over the other party, however, is obtained by serving those papers, the petition for dissolution, on the respondent in the state of Florida, by filing an answer, or if the person is out of state and we have long arm statutes, a long arm service that takes place outside of the state if the respondent isn't in Florida. But that person has to have certain statutory connections with the state, and we usually look to minimum contacts rules. And these are concepts that if you don't know already, you'll learn more about in civil litigation. If the court has jurisdiction over the parties, then it has jurisdiction over all of their assets. So if the court has jurisdiction over both parties, meaning that one of those factors of service, proper service, I should say, or an answer, or long arm service outside of the state because there was minimum contacts statute was met, they will have jurisdiction over all of their assets. Now, children are another story. For now, focusing on jurisdictional issues that relate to the property. Children have another set of jurisdictional issues that we'll talk about in another lecture. Fourth, there is jurisdiction over the property. If both parties are before the court, meaning that there was proper jurisdiction in the first place, that's no problem. The court can take care of everything. But it could be the problem if the respondent can't be found and served. And in this case, the court can retain jurisdiction of the case and over much of the property if a notice of action is published in a local newspaper. In this case, there is no jurisdiction over property outside of the state because the court, without both parties appearing before the court through proper service, the court won't have jurisdiction over property outside of the state. However, if the respondent's living outside the state and that respondent is properly served with a divorce petition, the court can award real estate in another state. So, just the service, and I should not just call it service generally, but proper service of a non-resident is vital to jurisdiction over the property outside of the marriage or outside of the state. All right. And it just that is what you always want to strive for as a paralegal working in a law firm when you file a dissolution of marriage. How are we going to get the best possible service that will not interfere with our jurisdictional issues? Dissipation of marital assets. Among the factors that a court must consider in making equitable distribution is the intentional dissipation, waste, depletion, or destruction of marital assets after the filing of the petition or within 2 years prior to the filing of the petition. The statute also contains a catch-all factor by which a court may consider any other factors necessary to do equity and justice between the parties. And I'm referring to the statute on equitable distribution. Under that catch-all, it's permissible for the court to consider dissipation occurring more than 2 years before a case is filed. And an example is the Amos versus Amos case, where the wife transferred marital property, which were shares of a family business, to her brother 3 years before the filing of a petition without the husband knowing about it. The trial court included those shares as marital property and charged them against the wife's share of the distribution, and the First District affirmed that decision in an appeal. The statutory provision authorizing the court to consider dissipation of assets after filing of a petition for dissolution, however, has been severely limited by the case law, as with the Amos versus Amos that extended the statute beyond the 2 years that the statute provides for. But the authorization to use that discretion that we've talked about as being so broad, it's limited a lot by case law. The court tends to look to the dissipation that happened during the pendency of the dissolution proceedings. So that's important. A quadro, that says QDRO. That is the acronym for Qualified Domestic Relations Order. We, as I noted, pronounce that as quadro. Alas, here we are. The employee retirement plans that a spouse has may be divided between the spouses. The quadro is an order that directs the plan administrator. So the retirement plan administrator is given an order from a judge that says, you will do this. Split this in half. Split this in a third and 2/3. Split this 75%, 25%. Split it in half, because a retirement plan is the sole property of one of the spouses. So the quadro directs the plan administrator to do this, and that way this one plan can be treated as a separate plan, and each person has their own asset now. It only applies to what they call qualified plans under the federal law, and they call that federal law ERISA. That stands for Employee Retirement Income Security Act. So the QDRO is, and the paralegal's role in this is usually, we contact the plan administrator, ask them to send the form that they require for a QDRO, help to prepare the form based upon the situation, make sure it gets to the judge, gets signed and sent back to the plan administrator, and then the plan administrator does the rest. Plans have an entire department that does this type of work. It would be very interesting, but anyway, alas, we are ready to go on to the references, and let's do that. All right, here it is. These are the references that I that I used to cover this lecture, and that's it. End of story. Thank you.